Hello, everybody. Let me open up the comments window here to just make sure that I can. Gosh, my hair, every time I do one of these, my hair is like crazy. Can people hear me all right? Just type something in the chat box if you can. I'll give it a couple seconds here. Okay. I'm assuming that I'm okay. Welcome to the Friday before a holiday weekend. It's great to see you. Thanks for making time this afternoon to chat with me, or the morning if you're on the East Coast. I'm sure people are ready to get started on the holiday weekend, so I'm just going to get right into it. And here we go. Today we're going to be talking about the perils of working as an independent contractor. So, oops, and let me just fix this background because that's kind of weird. Okay, there we go. So we're going to be talking a little bit about the pitfalls and perils of working with independent contractors. Everybody's super crazy busy right now. I know that lots of people are thinking about expanding their business by bringing on ICs, and it's a little bit complicated. It's not necessarily as easy as you might think. So we're going to talk a little bit about it. There's the information for where you can find me if you want to reach out. Again, my professional responsibility disclosures. This is attorney advertising, or might be viewed as attorney advertising. This is for informational purposes only. I'm not intending to provide specific legal advice. By participating in this webinar or viewing the recording, yes, it will be recorded, you're not creating an attorney-client relationship with my firm. Prior outcomes don't guarantee future results. And also, because we're going to be talking a little bit about tax issues. I am not a tax attorney. I am not a CPA. I am not a tax expert. I am not a mathlete. I can barely do long division. But we're going to talk a little bit about things that might have implications where you might want to consult with either a tax attorney or a or your tax professional, a CPA, if you use one. You've probably seen this screen before. I'm just going to skip over that. This slide, or a variation of it, makes it into pretty much every presentation that I've been doing lately, that travel is loaded with risk when you're selling travel. I have added one thing to this list, in addition to fraud and scams and things that can go sideways when people are traveling, handling client payment information. Also, independent contractor misclassification. That is a huge problem, and that's one of the things we're going to touch on today. So here's I'm going to just kind of set up the frame up the issue of why it's important to get this right when you're classifying someone either as an employee or an independent contractor. Let's start off with what an independent contractor is compared to an employee. An independent contractor is a person or an entity, like a business entity, that is contracted to perform work for or provide services to another company. So independent contractors pay their own Social Security and Medicare taxes. The company does not pay benefits. If you live in a jurisdiction that requires you to give benefits to an employee, independent contractors, you generally don't have to do that. So for that reason, it's pretty easy to hire somebody as an independent contractor, except if you get it wrong. Employees, on the other hand, are people who are hired, not contracted necessarily, to perform work for a company. The company does have to pay taxes and may be required to provide certain benefits. For example, if you're registered as an employer, you have to provide workers' comp, unemployment. You need those insurances. You may be required to provide health care if you have, or other benefits if you have over a certain number of employees. Here's where it gets tricky. There are different tests for what constitutes an independent contractor, depending on who you're asking. So at the IRS, there is a common law, what's known as the right of control test. It's an agency test, which has a legal meaning, which I'm not going to get into. But for tax purposes, if you meet the definition of the common law right of control test, you're good to go with the IRS. And the central question there is, how much control does the agency exert over a contractor? And we'll talk a little bit more about this in a minute. The Department of Labor, also at the federal level, has a completely different test for what constitutes an IC. That test is known generally as the economic realities test. And that question is, how integral is the work of the IC to the agency's business? And then at the state level, there are all sorts of different tests that exist from state to state. The one that seems to be more common than others is known as the ABC test, and we'll talk about that as well in a little bit. Okay, so let's start with the IRS common law right of control test. This is a very fact-specific test. It's not like you check three boxes and you're good to go. They look at the totality of the circumstances when the IRS is looking to determine whether somebody is properly classified as an independent contractor. There has traditionally been a 22-factor test that is basically a list of 22 different things that you do put into the mix when you're doing an analysis. But more recently, the IRS has started to apply a three-factor test, which really looks at behavioral control. How much do you control the behavior of your ICs? Financial control, to what extent does the IC control how much they earn? And then relationship control. How easy is it to get into or out of the relationship with your IC? And if you get it wrong, there are civil and criminal penalties. The Department of Labor Economic Realities Test is also fact specific, but it's very different. The principal question here, as I mentioned earlier, is to what extent is the work that the IC is doing integral to the central functions of the business? They also look at how permanent is the relationship, to what extent does the contractor invest in facilities and equipment, and there is, to some extent, a question of control, opportunities for profit and loss. Some of these are duplicated in the IRS test, but generally speaking, if you've got, for example, a sales agent who is working for your agency, that sales agent is selling travel. And if that is the principal function of what your agency does, the DOL test is going to be a tricky one to navigate. And then we've got the state law ABC test. So under state law, I'm just going to talk about the ABC test. I'm not going to talk about all 50 states and what the variations are between them, because then we would be here all day and nobody would ever get to go to a barbecue this weekend. So the state law ABC test, which was the test in California, it's also the test in New Jersey and several other states. Under the state law ABC test, you are presumed to be an employee. That's the baseline. Everybody's an employee unless you're not. And if you're not, it's because, one, you're free from the control of the hiring entity. Okay. They perform work that is outside the usual course of the hiring entity's business. That's potentially a problem. And thirdly, that they're customarily engaged in an independent trade, occupation, or business. So, travel agencies, travel advisors, it's pretty common for an IC to be independent in a travel agency if you're a sales agent. But the question here, the middle one, is the B part is the problem. Are they providing work that is outside the usual course of the hiring entity's business? Again, if you're a travel agency and you're selling travel and you've hired an IC to sell travel, they're not really doing work that's outside the usual course of your business. Okay. So there's a conflict there, right? So there's a different test at the IRS than there is at the Department of Labor, and then there's a completely different test in your state. So the economic realities test and the ABC test, as we talked about earlier, those are very difficult for most travel agencies to satisfy. In California, where the ABC test was in play, California specifically solved that problem by exempting travel advisors. But there are criteria that you have to satisfy in order to meet that exemption. ASTA, again, I'm a huge proponent of ASTA. They do a great job. They have been lobbying at the federal level for several years now to try to reconcile those definitions at the federal level in favor of the IRS test, because the IRS test is a lot cleaner, a lot easier to navigate. But the upshot of all of this is, if you are hiring independent contractors in your agency, what's in your contract with that IC really, really matters. And I've talked to a few people who have independent contractors. They don't even have a contract. And that's an issue, because if you get audited by the IRS, the Department of Labor, the state Department of Revenue, or the state Department of Labor, the first thing they're going to look at is what's in your contract and how is that relationship defined. So, if you're one of those folks out there who thinks, "Oh yeah, I really get along great with my ICs. They've been with me for decades. We've got a great relationship," that might not fly. And so here are the things that I would put into an here are the things that you can clarify in an IC agreement. And I'm not going to read all of these things because there's another slide that's coming, but it's a lot. To what extent are your businesses integrated? Do you train people? Training is kind of a buzzword that connotes employment. Um, how flexible is the schedule? If they have assistants, are you paying for them or are they paying for their own assistants? Do you control where the work is done? Other things, can they work for other companies? Um, do you demand that they work for you full time? Um, uh, all of these things and control over ending the relationship. All of these things are things that you can clarify in your independent contractor agreement so that when you get audited, somebody can look at that contract and say, oh, yeah, like look at all these boxes that they've checked on the test that we're using. This looks pretty clear that they're going to be an IC. Of course, the central question is really what is your independent contractor doing? So I put these two. I've been getting requests to draft IC agreements in two different areas primarily for travel agencies. The first is for sales agents or travel advisors who are working as ICs. Most of the time, those people are commission based, which means that they can determine how much they work, how often they work, what their hours are, and of course, how much travel they book is a direct function of how much they earn because they're paid based on commission. So that is helpful for classifying somebody as an independent contractor. The IC model is also pretty common among travel agencies. And so that is helpful as well because it's kind of the way the industry is set up. And to some extent, most ICs are selling to their own clients, although maybe they might get occasional overflow leads. So again, they're independent and they're selling independently to their circle of influence. Uh, the other requests I get are for people who are bringing on an admin assistant or somebody to do social media. So if you've got a booking assistant or a social media manager and you don't want to have to withhold taxes and pay payroll and get set up as an employer and have to get a workers' comp unemployment insurance, it might be an attractive thing to hire those admin assistants as ICs. But if they're doing work that is um, commonly done by employees, if you were a mature business that had an office and you were hiring somebody to come in and work on an hourly rate doing filing and research and answering the phones, those are types of things that look like, or managing your social media accounts. Those are things that look like things that employees do. And certainly, if they are doing work that is client facing to some extent, you're going to want to give them work direction. You don't want them going off there and going off and kind of doing their own thing in a way that adversely impacts your brand or your relationships with your clients. The one thing that where you might have a room to retain somebody as an IC rather than an employee is if they are in the business of providing virtual assistant services. So if it's a standalone company, they do that work for your agency and they do it for 15 other agencies. You've got a contract where they send you an invoice at the end of the month and you pay their fee. That helps. That looks a little bit more like they are a independent business that's providing services to you rather than your friend who is thinking about becoming a travel agent someday, but in the meantime they're just going to help you out um, uh, because you're so busy. So um, so you can see kind of where the nuances are and how complicated it is. Here's why it's important to get it right. There are civil penalties. If you get it wrong, you could have to pay back taxes. You could have to pay fines and penalties to the IRS. If the Department of Labor comes after you, they might find that you should have been paying minimum wage and overtime for all the hours that your independent contractor worked, and that is potentially a hefty bill for you to pay. So you want to be careful about that. But in certain extreme cases, there are criminal penalties. So if you've pulled down a contract off of the internet, or if uh, and you know just and or you've purchased it from somebody who tells you that there's a warranty, here's the thing: criminal penalties. You could go to jail if you get it wrong, and you get it wrong intentionally. So be careful about that. State law penalties. Uh, there could be unemployment insurance. If you fail, there are fines for failing to have unemployment insurance, workers' comp, state taxes, state minimum wage. In addition to federal minimum wage, there's state minimum wage. So if you get it wrong, it's expensive, and if you get it wrong and it's willful, you could even wind up going to jail. So, um, so here are the nuts and bolts of working with a contractor. I'm going to talk a little bit about some of the mechanics here. The first thing that I see a lot of people doing, and I have a view, I've talked about this with other travel industry attorneys. There are only 7 or 8 of us in the entire country who do this work for small travel businesses, and we all get together and we talk from time to time. I think some of my colleagues don't think this is as big a deal as I do, but I have a strong view that it is probably not a good idea for you to allow your independent sales agents to start their own businesses under your under your um, under your umbrella. If you're bringing on an IC as an independent salesperson, I don't think there's less risk. In fact, I think there's actually more risk if you allow them to start up an independent business under your brand. Now, the host agencies that are out there are lots of host agencies out there that are very, very good, especially the members of PATH, the Professional Association of Travel Hosts. Those businesses are complicated, sophisticated businesses that have been up and running for a long time and have people who've been in the industry for a long time. So if you're relatively new and you're getting really busy and you want to bring somebody on as an IC and they say, yeah, well, I want to have my own brand and I want to have my own website and I want to, do all of this other stuff, you're giving up a lot of control um, over what they're doing with your credentials or what they're doing with your agency's convention. And the thing that I really don't understand is why a hosted agency would turn itself into a host agency. That just doesn't make sense to me. The other thing that I see people doing that I think is really kind of weird is they offer sub agents commission splits that are along the lines of what they would get if they went to a host agency. So for a host agency is going to give you a commission split that could range between maybe 60% all the way up to 90, 95% in some cases. If somebody doesn't have the cost of running their own business, they're not investing in starting up a business and putting all of that capitalization into starting a new travel business. It is much more common, and I think warranted, if they're booking under your brand, under your nameplate, to see a commission split that's closer to between 50 and 70%. I see a lot of people who put ladders in their commission structure that's tied to productivity. And just give some thought to that. I mean, I understand why host agencies do that because that's more of an arm's length relationship. But if you are an agency and you're bringing on ICs who are working under your brand, under your umbrella, um, there may be people who are doing a lot of business. They're very productive, and yet they're doing other things that are problematic. And maybe the fact that they're cutting corners and exposing your business to legal risk, it doesn't warrant a higher commission split. So think about whether you want a flat commission split or whether you want to have a ladder like that based on productivity, because on one hand, you want to incentivize people to sell a lot of travel, but on the other hand, there are other things other than just volume that come into play when you're thinking about um, how happy you are with that relationship. You really need to have something in your IC agreement that talks about when commission is earned. And since most of the time we don't get paid until after our clients travel, you need a definition of commission when commission is earned that clarifies what that is, so that you're not obligated to pay commission before your agency has received it. And I think a simple commission structure is is pretty simple. I don't recommend having a really complicated, convoluted commission split structure because the more variables there are that go into how much commission your IC earns, the greater the likelihood is that you're going to wind up having a dispute about how it's calculated or whether you paid them properly. And I will say this too, that there are criminal penalties for failing to pay your IC's commission. There's a travel agency owner in Minnesota who was not paying commission properly, and was not paying commission at all in some cases. And the Department of Justice went after him. He wound up going to jail because a court found that he was committing wire fraud. Errors and omissions insurance. This is another reason why I think you don't want to let people book under their own brands if they're your ICs. Um, Most E&O insurers will tell you that you don't aren't covered for errors and omissions of your independent contractors under their policy unless they're selling under your brand and under your nameplate. So, so think about, what happens if your independent contractor is negligent when they're booking travel. Are they covered under your policy? Are your coverage limitations sufficient for the volume that they're doing? And if you do have independent contractors who have their own brand, are you requiring them to have errors and omissions insurance? And are you insisting that they add your business as an additional insured party on their policy? Because if they get sued and they're insured, but you also get sued from the same fact pattern and you're not insured because they're not covered under your policy, that's going to be a problem for you. So we talked a little bit about right of control. Um, I talk to a lot of advisors who say, well, I can't require my independent contractors to do this and this and this because then that's going to turn them into an employee. And some things you can't tell them to do. You can't tell them you have to show up on Thursdays and answer the phone between 2 and 4, and all sorts of other things like that. Giving them work direction is not really something you can do, but you can put procedures and workflows in place that protect your business. You can require them to adhere to best practices when they use your credentials to book travel. But when you're working with ICs, be careful with how you treat them. Work things like work rules sound like employment. Training sounds like employment. Hiring and firing applications. Those are all things that you would expect to see with an employee. And instead of training, maybe you have a mentoring program, or instead of or an orientation process. Instead of work rules, maybe you have guidelines for using our credentials. But you can absolutely refuse to allow somebody to misuse your credentials, and that doesn't necessarily turn them into an employee. This is something that I see a lot. It's kind of a trick question that I have on the questionnaire when I draft independent contractor agreements for people. If somebody wants an IC agreement, I send them a questionnaire. One of the questions is, do you want your IC to be exclusive? And when they check that, it is a red flag to me that I need to have a conversation with them about it. I have a strong view, and government agencies that look at these things tend to agree with me, that if you require an independent contractor to be exclusive, that takes away the independent part of the independent contractor. And like I said earlier in this presentation, there are huge penalties for misclassifying somebody. Truthfully, if you're bringing on an independent contractor as a sales agent, it usually doesn't occur to them, or it doesn't advantage them really, to split their bookings between more than one agency. But um, if people are doing that and you're not okay with it, you should draft an IC agreement with an eye toward giving you the ability to terminate the agreement without having to give a reason. And so, I suggest, a 30-day notice provision is more than fair. That if somebody's doing something that you're not okay with, to just say to them, you know what, we're reevaluating our IC relationships, and thank you so much for being contracted to our agency for the past year and a half, but we're going in a different direction, so we're going to end your contract as of this date. Terms and conditions documents. This is another reason not to let people start their own businesses under your brand. Um, do you have terms that can cover your ICs? If they're booking under your nameplate, under your brand, your terms and conditions document is going to cover them. But if they are independent businesses, do they have their own terms? Are those terms acceptable, or are there big gaps? Are they using something that was custom drafted for their business, or have they just pulled down some sort of cookie cutter template or form that they've purchased or licensed? Are your ICs actually following best practices by securing their clients to agree? You could put a policy in place for your agency that, as a condition of being an independent contractor, you must get every one of your clients who's booked under our agency umbrella to sign an IC agreement. That's not giving them work direction. That's protecting your business. And the other thing is, what about your workflow? If you've got subagents, do you have a workflow that is easy for them to follow the steps without cutting corners and inadvertently exposing you to liability? One thing I think happens is when you have a workflow where you're working with your clients and it is convoluted and it is complicated and it requires a lot of extra work for your ICs, that's when they decide, you know what, I know better than my agency owner. I can just go ahead and do it this way. And that's when things um, start to go sideways. So your workflow shouldn't be so complicated that it incentivizes your ICs to start making it up as they go along. Terms and conditions document. You've probably seen this slide before if you've seen other presentations that I do. These are all the things that go into your go into a terms and conditions document. These are all the things that you're going to want your ICs to be dealing with. If you do have somebody who is operating their own business under your umbrella, um, hopefully they've got a document that touches all of these things, because all of these categories, and it's not just 5 provisions, it's longer than that. But you're going to want to make sure that all of that is covered in their document. Also, credit card authorizations. You're going to want your ICs to get a credit card authorization for each and every charge. You don't want them taking numbers by email or text, and hopefully not over the phone. I did a whole webinar last Friday on this, which is available on my Facebook page and my YouTube channel. If you want to go back and see more about why credit card authorizations are important, you can go back and take a look at that. But also, you need everybody in your agency to be doing this consistently and to be doing it the right way. It doesn't turn them into an employee to require them to get credit card authorizations from all of their clients when they're booking under your business. Okay, and then we're getting close to the end of it. I think a lot of times when people enter into IC agreements, they're really excited about bringing somebody on board. They have a great feeling that this is going to be a really terrific relationship. And a lot of times it doesn't work out so well. And have you really thought about what's going to happen? And this needs to be in your IC agreement. What's going to happen when the independent contractor leaves? You're going to want to make sure that you've got something in there that talks about what happens to bookings that still need to be administered if they decide to go someplace else, or if you decide to cut them loose. You need to figure out what's going to happen to your confidential information and documents and policies that you have that they had access to. Um, so what happens to those bookings? Who's going to pick up the administration if they're getting out of the industry entirely? Somebody's going to have to administer those. If the commission hasn't come in yet, how much of it do they get? Do they get the same percentage as though they were still working there? And then who keeps the clients? Do they get to keep the lead clients that you funneled to them if you did that? I see a lot of people who want to put non-compete clauses in their IC agreements. I strongly recommend against that because, first of all, non-compete clauses are completely unenforceable in some states, such as California. California, in every industry, a non-compete clause is unenforceable. In other states, they are highly disfavored. Um, but non-compete clause, just so you know what that is, non-compete a non-compete clause says if you leave my agency, you cannot work in this industry doing the same things that you were doing for a period of time. So, a sales agent leaves your agency, and you've got a provision in your contract that says after you leave my agency, you can't sell travel to anybody for a period of 2 years. That's a non-compete. Instead, I think what you want to do is you want to have a non-solicitation provision instead. Non-solicitation provision says that when you leave my agency, you can't poach my clients, you can't you can't poach all of my other ICs and get my whole team to follow you to wherever you're going. Those non-solicitation provisions are enforceable. They are much less onerous. You're not interfering with somebody's ability to earn a living once they leave you, and they're justifiable because you're protecting a legitimate business interest. And also, they can't steal your documents and policies. So, this is that's my presentation, and that's where you can find me if you need to. And I'm going to look at the comment section to see what we've got in terms of questions, because I feel like I just threw a lot of information at you, and so I'm going to put up some questions and try to answer them. So if you've got questions, we can take it from there. So, Jillian, how are you? Do you have a template that you suggest we use? I don't. I mean, just in my business generally, I don't sell templates because I don't believe that that actually protects you from the legal risk that we encounter when we sell travel. So I don't sell cookie cutter templates uh, or um, uh, those or the sample contracts. Every business works with ICs in a very different way. If you are acting as a host agency, I would put different things in your contract than I would put in somebody else's. So I don't. But if you'd like to talk to me about drafting a contract that is for the way you're working with ICs, that's the sort of thing that I would do on an hourly rate. But whenever I work on an hourly basis, I talk through with the client what we're doing. I give an estimate of my time. So I understand why small business owners are sometimes nervous to work with attorneys, especially if it's something on an hourly basis. But we're very committed to being transparent in our billing, and so I think I can say pretty confidently that my clients are not surprised by the invoice that shows up at the end of the month. They more or less know what it's going to be. Happy to talk to you about it. I was with a host agency who told agents they could not work with another host agency. Was or is that legal? Hi, Helen. So that's the exclusivity thing, right? So I don't believe that if an agency looked at it, it's one. Let's just say this: it's one factor among many. If somebody is restricted from booking travel with other host agencies, that that is something that I think weighs pretty heavily on the employee side, because that exclusivity makes you look more like an employee. If you don't have the ability to contract with other agencies, um, there are lots of us who are hosted, and we also have our own industry credentials. And so, and in fact, my travel agency is one of those. We have our own, we are hosted and we book, I would say, almost everything using our host agency's credentials, but we also have our own IATA. And on once in a blue moon, we'll book something on our own. But that's very, very rare for us because most of the time it just doesn't advantage us at all because we get better commissions through our host agency. But our host agency, because they do things by the book and they're compliant with the law, understands that there's not, it's not within their purview to restrict how an independent business operating under their umbrella is doing business when it doesn't involve them. And that's the same reason why you don't necessarily want to bring on an IC who's running their own business under your umbrella, because they could be doing all sorts of other things that you don't even know about that could be problematic. So, um, uh, minimum threshold of sales. So again, this is a one factor of many. As I mentioned earlier, the there's not a bright line standard for what constitutes an IC. It's not like you check these boxes and you can do this, you can't do that. If people have sales quotas, sales thresholds, that is something that makes somebody look more like an employee. But if they're terminating the relationship for that reason, I draft in all of my IC agreements that I draft for people, I put in there that they don't have a sales quota, because that uh, is a strong signal to the person who's auditing you that you're on the right side of the issue. So so that is um, that's what I recommend. Stephanie has experience with Department of Labor audits and saw thousands of penalties and misclassification. Yeah, I have a colleague. There's an agency that I'm aware of that had an issue where one of their independent contractors filed an unemployment claim, and they thought it was a tax thing. They didn't realize it was a Department of Labor thing, and they sent it to their accountant instead of their lawyer, and it wound up costing them tens of thousands of dollars in fines and penalties, and they've been wrangling with the State Department of Labor for months over that. So yeah, exactly the reason why you don't want to guess wrong. So. Um, uh, let's see here. So I don't think I have very many more. Okay, here we go. We've got another question from Helen. Excuse me. Yeah, so the sales quota question, exactly. I think what you're saying here, Helen, is what I would recommend. There is a cost to your business to having ICs, and I would just, this is not a legal thing, but I would just encourage you to think about, if you're super crazy busy, and that's one of the reasons why you want to bring on an IC. It's going to take a lot of your time to make sure that they are doing things the way they should be doing in order to protect your business from all the legal risk that you're taking on. So it doesn't necessarily. This is a long way of answering Helen's question, but it doesn't necessarily save you time to bring on ICs. If anything, it might mean that you're busier than ever because you're trying to take care of your clients and you're trying to make sure that your ICs are growing their business. So think about whether you want to grow your business this way by adding more people, or whether you want to grow your business this way by becoming more efficient. Um, give some thought to that. But as far as the sales quota question, I would say it's the same thing as, if they are, if they're double breasted and they're working with another agency and you're not crazy about the fact, maybe you suspected that they're taking leads that you've given them and booking them with another agency. That's a problem. You want something in your contract that says they can't do that. But the answer to that is not to tell them they can't affiliate with another agency. The answer to that is to have something in your contract that deals with that issue. Um, and then if you find out that they're doing that and you're not okay with it, you give them notice and then you cut them loose. Okay, so I'm not seeing any more questions. I think we've got a fewer number of people this time than we did last time. This is going to be on my Facebook group going forward. I mean, the recording will still be there, and also it'll be on my YouTube channel. I'll add it there as well. If you have questions about this, you can reach out to me. I do draft IC agreements for people, and I'm more than happy to talk to you about it. If you've got something you're using now and you'd like me to take a look at it, you can send it to me, and we can set up a complimentary consultation. And as Helen mentioned, because I participate in the ASTA attorney referral program, my hourly rates are discounted by 15% for ASTA members. So join ASTA if you're not already. They deserve your support. They're a fantastic organization. All right, well, I'm going to get going, but enjoy the holiday weekend, everybody, and I hope you have a great celebration. And if you're celebrating, and if you are, I mean, I know the Memorial Day is not a celebration necessarily, but just take a moment to give thanks to those who sacrificed for our country, making the ultimate sacrifice. And thanks very much. We'll talk soon. Take care. Bye.